Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, lovely people. It's another Saturday, and we're here live with you on The Community and the Law. My name is Oreku Frimpong. This afternoon, I am going to look at the EUSS retention of rights application, how to avoid refusal. And as we do, Lawyer Charles Asma will be on hand to help us look at that. And we're doing this courtesy BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors, they help us with all our immigration matters. They help us with issues of family, issues of understanding the law, updates from the Home Office, and the rest of it. So if you want a trusted friend, trust BWF Solicitors. Call them on 0208 493 7340, 0208 493 7340. The second Saturday of October 2025. is a month we call the Pink Month, where we're creating awareness on um, breast cancer, and also we're celebrating Black History. So definitely things are going to happen, and we're going to update you on all that. But most importantly, we want to empower you when it comes to the law. It's the community and the law. Right? Next. And we are right on. And I want to welcome all of you live on BWTV at BWF Solicitors and at BWTV, both on Facebook and YouTube. We are going to get into the journey together. And this afternoon, as I mentioned, we're looking at EUSS retention of rights. What is that? And how do we avoid being refused when we put in an application once we are trying to exercise our EUSS right? Lawyer Charles Asma from BWF Solicitors, as I said, is, I guess, the resource person, and he's going to take us through that so quickly and very elaboratively. Then again, we are also going to update you on some of the things that have happened, some updates from the Home Office, and also to let you in on the bits about our campaign against breast cancer. Is the month of October is the Pink Month, and we are collaborating with all organizations that are going to really bring light or pour light or put light on the issue of breast cancer to let you empower yourselves so you don't fall foul to that. Once again, my name is Ulrich Frimpon, and I said, well, I always come your way by courtesy of BWF Solicitors. And if you have joined us live on Facebook and YouTube, I want to welcome you and say thank you so very much. So, what you do, we do the housekeeping. When you come in, you like the page, you share, and also announce yourself in the comment section down below, and then we will welcome you, like I'm going to do to a few that have really joined us. And I know some common names and common members in the classroom are going to be here. Let's see who we have first. Can I predict somebody? No. Let's actually see who is here. Well, Adair Terrible, I was just going to mention your name. Adair Terrible, good afternoon to everyone. He says, thank you so very much for joining us. Adair, you are with us on Facebook. God bless you. Solomon Dazi, wow. Yes, Solo. Yes, we are here. And thank you very much. You have joined us on Facebook as well. God bless you. Announce yourself, share the page, ask people to join us. And if you are new here, what you do is you subscribe to the page so that whatever it is that we bring out, you will have a notification and you find us. Now remember, we do this every Saturday afternoon between 4 and 6 p.m. UK time, and we're doing this courtesy BWF Solicitors, our trusted friends when it comes to the law. Congratulations to our very own Pamela. Pamela last week celebrated her birthday. We celebrated her, and then there was this feat that she achieved, and we would want to share with her. We proudly welcome you, Pamela, to the position of trainee solicitor at BWF Solicitors. And we're confident you will achieve great success. Like all trainee solicitors who come through to BWF Solicitors, you have access to exciting opportunities and strong foundation for a long, fulfilling career. So having achieved that, Pamela, we say congratulations and wish you all the best. Um, it's hard work. It's about commitment. It's about dedication. All these qualities you have already. So once you have signed that contract and you have started, we wish you all the best, and we know you'll come out successfully at the end of the day. This week, we are celebrating Customer Service Week, and we at BWF Solicitors, we believe great service starts with care, commitment, and understanding. So, as we have gone through Customer Service Week, we want to celebrate our dedicated team and loyal clients who make it all possible. And you know what? When these clients experience the service that we have, they give us feedback. And Joseph has brought us one. He says, I had an amazing experience with BWF solicitors during my spouse visa application. I want to sincerely thank Frank Anor, who guided me every step of the way. His support, clarity, and patience made a huge difference. And I also want to acknowledge, as Joseph says, I want to also acknowledge Bernard Usu and Ania Akofio Soa for their professionalism and dedication. The whole team made the stressful process feel manageable. And I'm truly grateful for their help. I highly recommend BWF solicitors. Well, thank you very much. And more reason for celebrating Customer Service Week. We so committed to serving you so very well. We're committed to meeting your needs, and we're also committed to make sure that you leave our premises very satisfied and with a smile. So thank you very much, Joseph, for your feedback. Those of you who have experienced the service, let's give the feedback for people to also appreciate what we offer and what they can get when they come in here. It's October 2025. We wished you happy new month. And we're saying that we have a campaign we want to get you to join us go on. It's Breast Cancer Awareness Month. And this whole October, we're going to bring you messages about how our dear sisters, mothers, and our ladies and friends will be able to examine their breasts so that if there are any signs that you may be having the symptoms of breast cancer, you will quickly go to the hospital for them to check for you and then remedy the situation. Those who have suffered that and are in the situation, please don't give up. Let's continue to educate other people, and then they will also stay safe. So, with Pulse Ghana and their campaign, together with BWF Solicitors, we have this message.
A breast lump is not the only sign of breast cancer. Here are 7 other signs that you should be concerned about. They could indicate breast cancer. First off, a change in your breast size or shape, like this, could indicate breast cancer. So the first step is to know your normal breast so you could easily pick up any changes in it. 2, skin dimpling or puckering. This is when the skin of the starts to look something like an orange peel, just like this. This can point to inflammatory breast cancer, and you should quickly run to the hospital if you notice this. 3, have you suddenly noticed any redness or thickening of the skin of the nipple or the breast itself? That could also be a sign of breast cancer. 4, your nipple suddenly turning inward, like this picture, known as an inverted nipple, is also a classic sign. And there's also bloody discharge from the nipple or ulcerations of the breast like this. And of course, the popular lump in the breast, but not just in the breast, even a lump found in the armpit without any lump in the breast could indicate breast cancer. And that points to you not to play doctor, but to quickly run to the hospital to have your breast checked by a professional. So, as we're in the month of October, do well to educate yourself about the subject of breast cancer. Join the movement in the fight against breast cancer and do not stigmatize. Breast cancer can happen to anyone, both male and female. Be kind to one another. My name is Dr. Mamiefa Malfa Jifa Pudute, but you can call me Dr. Jifa, and this is Pulse Health.
Be kind to one another and being kind and very friendly with everybody. Let's join the campaign. And I want to also, as doctors mentioned, it doesn't only happen to females, it does happen to men as well. So whilst we following the steps of examining ourselves, let's also men do that and stay safe. Thank you so very much, Pulse Ghana, for that campaign. We'll come with another campaign same time next week. So let's look at Nugget. But before then, can I quickly introduce our resource person? Because I'm going to throw this at him anyway. So let me introduce Lawyer Charles Asma, our friend, our partner, and also, I guess, the resource person for this afternoon, coming from the stables of BWF Solicitors. We have Uncle Charles. Good afternoon.
Good afternoon, Brakuku.
How are you doing?
Very well. How are you?
Well, we thank God for small mercies. I'm doing good. By God's grace, we have had the strength to be able to come in and serve the community. So, yeah, I'm glad I am here.
Awesome. Thank you. Yes.
Okay. All right. Prior to that, we were looking at the nugget. So, with your permission, I will go ahead and look at it so then you can take us through it. Traveling to and from the place of work, we are being told that it does not count as time work under the National Wage Regulations of 2015. And we're looking at employment that involves ordinary commuting, even if lengthy or burdensome. And being told that it does not need to be paid at the NMW, unless NMW, that is National Minimum Wage, unless it falls within Regulation 34. Unless travel occurs during working hours or meets the conditions of Regulation 34, it is not considered time worked and is therefore not payable. For low paid or itinerant workers, the risk of unpaid travel consuming a substantial part of the working day may be unfair, but only Parliament can amend the law. Revenue and Customs versus Taylor Services Limited and ORS 2025 English and Wales Court of Appeal case number 956. Uh, we're talking about wages. At the end of the month, we think that is not even enough, and we use most of that to pay for our community, our commuting. Sorry, that's a word. Our commuting, traveling in and out of work. And do I have the right to ask my employer to pay for my transportation? I think that's what is being discussed here. I guess I am right to ask one.
Yes. So we have what is considered to be the normal working time
Mhm,
and what falls outside the normal working time. Your normal working time includes your travel time to work, to and fro. So from home to your place of work
mhm,
is your normal working time. So from the morning up to the evening, whether it is 9 to 5 or 9:30 to 6 or whatever it is, that is your standard time.
mhm,
What about if it's going to if I have to travel to work and travel back home?
mhm,
Travel to work, travel back home, give and take will be more. If you add to the normal working time, then you have more than the usual. Who pays for that travel time? If you are working the standard time, morning to evening, your job is to arrive and work. How you
mhm,
arrive is your business. Whether you come and live at the office or at the workplace so that you don't have to travel, it's your business. It is harsh, but it is the rule. What it means is that anything that is outside the normal time or the travel time will have to be paid for. Anything within must not be paid for. What do I mean? There are some people who go to the normal place of work and then they have to make rounds throughout the day as part of their job. Then that will be outside the normal travel time work to work. So such person can claim travel time, extra travel time. But if you are traveling from point A to point B and return from point B back to point A, which is your home, then even if what you are spending to get to point B from point A is more than what you are getting paid for, then it is not worth the job. But it's up to you. So you can't tell your employer that, well, I'm getting £12 an hour, but I'm taking cab or Uber. That is costing me £30 every day. So I'm losing. So add something to it. that is not the rule. Unless you're able to prove that I come to work and I take Uber to do the business rounds and I get back to the workplace, and from the workplace I go home, then you can discuss those extra hours that you do or extra travel that you go through. Otherwise, even though it is not fair that you are spending more on transportation than you are being paid for, the employer is not breaching any rule. And HMRC will also not reimburse you for those travel time. Unless, of course, so now let's go into HMRC. The question here is, can I then go to HMRC and claim for those hours of travel time or travel cost? HMRC will apply the same rule. You travel from point A to point B. That is your normal travel route to work. Then HMRC will not reimburse or refund that money because it is part of your job. Anything else, HMRC will reimburse. The only point where HMRC will come in is where you drive to work. If you drive to work, there is standard mileage calculation system, and the HMRC has standard mileage computation. Anything more than the standard mileage, HMRC will reimburse you. So that is for those who drive to work. Other than that, unfortunately, no.
So if I drive to work, my work starts at 9 o'clock, and I drive to work and I get to work before 9 o'clock, and I leave work after 5, and I travel about an hour back home. We saying that my contract is between 9 and 5. So whatever it is I do before 9 and after 5, the employer does not have to know. Whatever expenses I incur, the employer doesn't have to know. And maybe the second part of my question is, if I negotiate with the employer to say that I travel X amount of miles to come to work, so you need to pay me, and the employer agrees, then I can claim it.
So, 2 points you've raised. First, is that travel or that journey part of your, well, not that is part of it, but you must go to work. That's the starting point.
Yeah.
So, how much it will cost you to get to work? Whether you are going to take helicopter, you are going to take standard aeroplane, you are going to take train, you're going to take taxi, or you're going to walk. Nobody cares.
Mm.
Your contract says report to work. Now, once you report to work and you have something else to do after you have arrived, for example, you have to go to different business locations for inspection, then
Mhm.
that is beyond your work, isn't it?
Yeah.
That is extra cost.
Okay.
That is extra cost. So HMRC has a term, wholly and exclusive.
Okay.
Wholly and exclusive. Of course, if you're an employer, you know how to deal with HMRC because you are dealing with HMRC. So that one is between the employer and the HMRC. A lot of employers will go through the wholly and exclusive analysis their own way. That is the employer's business. But you, the employee, if it is not wholly and exclusive, HMRC will not reimburse. However, if the employer feels that as part of the time there is
Hmm.
travel allowance, such travel allowance will be part of your remuneration. Such
Okay.
travel allowance will be part of your remuneration. Either the employer at the end of the month will add the allowance to it so that you pay the tax on it, or the employer will give you a voucher to be able to cover that travel cost. Such conversation, which is your second question, is between you and the employer. But
Hmm.
the employer will then ensure that it is part of your remuneration or wages. So when, for example, you are filling your, if you are if you have opportunity to file tax returns, HMRC will ask you, in addition to your standard wages or remuneration, do you receive any other allowance for clothing, for transportation or commuting, or for any other thing? You have to declare, and that will be part of your wages, based on which HMRC will then compute your tax to assess whether you've paid the right amount of tax or not. But I think the nutshell is this. Can I tell my employer that I am spending more on transportation than I am getting in wages, and ask my employer to pay back? No. Why not? Because if you are traveling from point A, which is your home, to point B, which is your workplace, how you get there is your business. The employer's business is to ensure that within the minimum wage regulations, you are paid the minimum wage. And it is the minimum wage that you will use to manage your life or yourself. The employer will not be at fault. However, the employer, if so wishes, may convert such compensation into allowable wage so that it is added to your wages. And the employer will call it enhanced wages or increment in wages or allowance.
Somebody just sent an interesting question, and it goes with the way of working these days in various organizations. Hybrid working. Sometimes people work from home, sometimes they work in the office. And I was asking, if I'm working from home between 9 and 5, I'm working for my organization. I'm using my own electricity, I'm using my own broadband and heating, possibly. Should the employer be asked to contribute towards that because during that time I'm working for them?
Good point. The employer may say no, but you can then go to HMRC to claim back such expenses, which are wholly and exclusive to the work you do. So, for example, I'm currently doing this, what I'm doing now. This is not part of my business contract anyway. But if this were to be part of my business contract, and I'm using my internet, I'm using my computer, I'm using my home space, then I will look at how much of this home expense goes towards this business activity. Then I will tell HMRC that in addition to XYZ, I spend this, which is about, let's say, 10% of my household expenses in terms of the utilities and rent and stuff. And so it is, let's say, £500. The employer may not give me, but I'll tell HMRC that I spend X amount. So I want to have opportunity to file self-assessment. So self-assessment is not only for people who are self-employed. You can tell HMRC that for X and Y reasons, I want to file self-assessment. Once you file your self-assessment, you have the opportunity to claim back such exclusive and wholly business expenses or work-related expenses that your employer has not refunded or reimbursed. And that will then increase your allowance, what we call personal allowance, so that your tax bill going forward will come down. And if you have already been paying tax, because you are now claiming all these allowable expenses, eventually HMRC will refund some tax you have already paid. But that is between you and HMRC. It has nothing to do with the employer. If the employer wishes, they will convert it. And once the employer converts it, then the employer will let HMRC know so that your wage bill goes up, and that will also reflect on the tax you have to pay eventually. So it's all a mixed bag of analysis within the tax spectrum and the minimum wage spectrum, and what you can do with your employer or with HMRC, which is the tax cost custodian. And so with this particular case law, HMRC, can see that it's a HMRC case between an employer And the question here is, should extra cost be part of the conversation when it comes to whether the employer should pay more or not? And all these things, the bottom line is that if it is not wholly and exclusive to the business, no. So if you go 9 to 5 and you for example have to travel for 3 hours or 5 hours to get to work and 5 hours to get back home, which is 10 hours, and you are working 7.5 hours, that makes 17.5 hours. So the 7.5 hours is fine, but who pays for the 10 hours or the 5 extra hours? You pay for it. Otherwise, you have to relocate to where the business is so that you spend less on travel costs.
So, ladies and gentlemen, traveling to and from the place of work does not count as time work under the National Minimum Wage Regulations of 2015. So, for low paid or itinerary workers, the risk of unpaid travel consuming a substantial part of the working day may be unfair, but only Parliament can amend the law. As I explained, it is an HM Revenue and Customs versus Tailor Services Limited and ORS 2025. It has come up, and I believe that it answers some of the questions that you may have. Listen, if it is not wholly and exclusive to the job you're doing, please, it will not be paid for. So you have to make your own arrangement, no matter how much it takes off your wages. So if, as I mentioned at the beginning, if it takes a substantial amount of your wages and you don't find it quite useful and convenient for you, you may as well advise yourself and look for something else that's closer to you that can save you a lot of money by way of transportation. It's a community and the law is brought to you by BWF Solicitors. And with that, I have this scenario. Can you help me answer it? Let's look at AC Kwansma, who works as a domiciliary carer with Abacus Care Agency. In a typical day, she travels for 4 hours to get to her clients to provide care. She works for 60 hours a week, including travel time of 20 hours. She was concerned that although she works 60 hours a week, she's only paid for 40 hours. She wants to take her case to the Employment Tribunal for an unlawful deduction of wages. So then I'm asking, is she likely to succeed? Three options. Look at them. One, no, because travel time is unpaid, as it does not involve working. Two, she will succeed because she travels to the client's homes, which involves paid time. Then three, no, because her contract of employment is for 40 hours a week. So Ezi works with Abacus Care Agency. And in a typical day, she travels for 4 hours to get to her clients to provide care. She works for 60 hours a week, and those 60 hours include travel time of 20 hours. Okay. She was concerned that although she works 60 hours, her pay was covering only 40 hours of those 60 hours, and wants to take her case to the Employment Tribunal for the employer to pay her back the 20 hours that she deducts every time. So then I'm asking whether she will succeed or not. Think about that, and I will ask you again. But today we're looking at something else. We're looking at the topic EUSS retention rights. What is that? How do you exercise the rights? And when you put in an application for your EUSS retention, how would you avoid being refused? That's what Lawyer Charles Asma is going to take us through, and we'll be going to the law, the regulations, and what there is. And then we will take your questions. You can send in your questions to 020, that's the phone line. You can call 0208 493 7345, or send a text or WhatsApp to 07399 208 468. 07399 208 468. Or you can leave them in the comment section down below, either on Facebook and YouTube at BWF Solicitors and at BWTV UK. We're taking this quick break, and when we come back, we'll start our discussion and we're looking at the topic at stake. Don't go away.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
EUSS retention rights, how to avoid making an application and being refused. We do this courtesy BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors, located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. Now, when it comes to all immigration matters, you trust BWF Solicitors. When it comes to the interpretation of the law and helping you navigate all those pathways to get to the right side of the law, BWF Solicitors. When it comes to advice as to what to do when it comes to property, investment, and also business development, you need lawyers to back you on that one. BWF Solicitors. 0208 493 7340 is the telephone number for BWF Solicitors. You can also call them on 004477 127 61884 004477 127 61884. BWF Solicitors are trusted partners when it comes to the law, and they're so well versed in what they do. And one of the lawyers from their stable is lawyer Charles Asma, who's our resource person and guest this afternoon. Now, Asma, EUSS retention of right application, how to avoid refusal. So let's look at how do the application, what we need. I remember last week we were talking about the ingredients. We were cooking, we cooked, and it was so delicious. This afternoon we want to cook again, and this time EUSS. How do we go about to set?
Thank you very much, Brakuku. Viewers and listeners, once again, good afternoon. Today's conversation is particularly important for two reasons. One, to remind ourselves that there is a rule when it comes to applying under EUSS, or when it comes to making an EUSS application on the basis of retention of right. And the second reason is that a lot of people are confusing themselves about the whole concept of retention of right application and the EU, and so a lot are making mistakes. So our aim this afternoon is to bring this to the fore, have a refresher conversation about this, so that we avoid such mistakes, and also to ensure that we are ready when we are ready to make an application, and we are ready to ensure that we avoid any potential refusal. So, EUSS, we know that is European Union settlement scheme, EU settlement scheme for all EU migrants and their family members who have to decide whether to remain in UK or to leave, because UK has left the EU from 2020. The reason for the retention became a point of law as to whether it is good or not so good for people to be punished for things that are outside their control. So we have Regulation 2016 with particular paragraph 10 of that wider regulation. It talks about things that can happen, which will then make the person who had the right to have retained the right. I'm going to give a context here. Somebody came to me last week, said, "Lawyer, I have a court case, it was dismissed. And my lawyer says that it's been sent to the next level, upper tribunal, and it appears that it's even gone further to the Court of Appeal, fighting a case for EU application and the retention of right." So I said, "Come, let me see." Showed all the documents, and I had to take him through, and eventually he concluded. And this is what we did. I said, "You are applying because something has happened." And he said, "No, no, 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 no. My lawyer said that I'm doing a retention of right application." I said, "There's nothing called retention of right application per se. Retention of right is a concept within the rules that gives right for you to make an application. So the application itself is not called retention of right, but it is the basis of the application, which is the retention of right." He said, "Lawyer, what do you mean?" I said, "Right. Under EU rules, there are two sets of applications. Either you are applying for 5 years pre-settled status under paragraph EU 14 of Appendix EU to the immigration rules, or you are applying for settled status under paragraph EU 11 of Appendix EU to the immigration rules. Under EU 14, you have not been resident in the UK for 5 years, so you have to be granted 5 years if you meet the rules. Under EU 11, you have been resident in the UK for 5 years, and so you have to be granted indefinite leave to remain, which is settled status. Now, when you are about to apply for any of these, you have to show that you meet the requirements. In showing that you meet the requirement, you have to identify yourself. Are you applying as a spouse, or you are applying as a child, or you are applying as a parent? 3 categories. And once you are applying under any of these set of relationship categories, the next stage is for you to identify yourself in terms of how long you've been resident in the UK for. So if you've been resident in your UK for 5 years, you can apply for settled status under EU 11. What if I have not been able to remain in the UK for 5 years? Let's say I've been resident for 3 years, for 4 years, or 2 years. But my family member is no more, or there is something that is now beyond my control that gives me a retained right. Can I here and now apply for another visa? And after explaining to the person, he said, "Oh, that means I didn't have to apply in May 2024 when the lawyer applied for me. Because when the lawyer was applying, I had been with my wife for only 4 years from the date of marriage.
Mm-hmm.
And so, even if I was still living with my wife, I wouldn't be able to have applied for indefinite leave to remain because I should show that I've been resident with this family member for example, 5 years. And then it clicked that retention of right is not a different application, but it's a basis of making the EU application.
Mm.
Let's break it down.
Okay.
We are looking at certain factors that are beyond the control of the individual. And when those factors are present, the person who already had right and that relationship factor has been taken away.
Mm-hmm.
Once the relationship factor is taken away, do you still benefit from the right or not? Under normal circumstance, if the relationship factor is taken away, then that is the end of you, isn't it?
Yeah, because that's
But
that's
within
the
the
reason you were granted, wasn't it?
exactly, you don't have any relationship again to pursue.
Mm-hmm.
But in the wisdom of the framers of the law, under Regulation 10 of Regulation 2016,
Okay.
they concluded that once there is any of these external factors
Mm-hmm.
happening or occurring, the individual should not be punished unduly because it is not their fault. And if it is not your fault and you cannot be punished unduly, then we say that the right you had must follow you. So you have retained the right.
The right. Okay.
I say that that means once you have the right, you can freeze it and use it anytime. So your right is kept in the freezer for you. It become ice block or whatever, but you can always use it when it becomes necessary under EU rules. What are these factors? We call them factors beyond the control of the individual or the family member of the EU national.
Mm.
So we call them supervening events. Supervening events because they have happened by the act of God or by act of nature. Example, death. Once death occurs,
Mm-hmm.
should you be punished for the death of your family member?
Obviously, no.
And because of that, should we take the right you had through your family member away from you?
The person is dead. You didn't kill the person. It's not your fault. So it's only fair that you are asked to keep your right.
So, when it comes to death or bereavement, your right will be kept intact because it
Okay.
is not your fault.
Okay.
Then you have acquired a right, a retained right,
The right. Okay.
because something has happened that has created that right to be retained or kept, regardless of whatever has happened. Death is one,
Okay.
bereavement. Then, what if your family member, your wife, for example, is still alive, but what brought you together, which is marriage, is no longer there? So, once there's divorce, should you be punished and the right taken away from you or not? The rules say you should not be punished when there is divorce, and so your right must be retained. So, divorce is also important. Relationship.
Divorce started by which of the partners? Is it you or the other person?
Still divorce.
Okay.
It doesn't really matter where it's coming from. All we want is it's happened.
It's happened. Okay.
Yes. Once the criteria for that is or are met, then you are okay. We'll come to such specific criteria.
Okay.
Then we've looked at divorce or breaking termination of the relationship, which is the marital relationship.
Mm-hmm.
We've also looked at bereavement.
Yeah.
There's also something that can occur which will break the relationship, stemming from abuse, and we call it domestic violence. So once there's domestic violence and one party, obviously the party at stake here will be the one that requires the sponsorship of the EU national. Because the EU national, him or herself, is okay under the rules. It is the family member that may not be okay.
Okay.
And so when there is domestic violence, which the family member may not have any control and may have to leave the relationship, then it becomes a factor for the family member to consider to retain a right. So we've looked at domestic violence, D.
Mm-hmm.
We've looked at termination of relationship, which is marital relationship.
Yeah.
We've looked at bereavement or death. And the third one is child custody. Child custody. So these four factors, I have christened it Dr. BC. So Dr. BC are the factors that you need to check whether you have it before you can consider applying on the basis that you have retained your right. Dr. DR and
Mm-hmm.
BC. So D, domestic violence. R, break termination of relationship, which is the marital relationship.
Mm-hmm.
Then B, bereavement, that's death. And C, child custody, which you still have.
Okay.
Right. Now let's open the first one, which is the domestic violence.
Well, by way of that, I just want to remind you who just joined us. Latas Asmas, you see him with us there, is telling us what it is that we need to look at and consider when we would have been said to have retained our rights. And the retention of a right as a partner or a dependent of a partner, so to speak, is we have bereavement, we have a divorce, and we have child custody as well. So he's going to take us through them one step at a time. So you get yourselves ready. If I were you, I would have picked my notepad and a pen or a pencil and be writing down notes. But you don't even have to worry because the recording will be on our platform until we show you another one or we update with another one. And it will still be there until it's taken off by either YouTube or Facebook. And at BWF Solicitors, both Facebook and YouTube, and at BWTV UK on Facebook and YouTube as well. And remember, we're doing this courtesy BWF Solicitors, our trusted partners when it comes to the law. Our social media handles, we have Facebook, Instagram, X, and YouTube as well. Yes, let's look at the various steps we would want to look at, or the various items, or various parts of this whole thing that we want to look at. You were talking about the very first one, which is bereavement.
Yes. So I think the point we want to establish from the outset is that no one should say that I'm going to make an application for retention of rights because it is not an application which you can make at any time. No. The only application you can make is EU pre-settled 5 years application or EU indefinite leave to remain settled status application. However, you can apply under any of these or for any of these, either based on your existing right or based on your retained right. Existing right is where everything is as before. Retained right is where something has happened to the relationship, and so you want to rely on whatever has happened. What it means is that before you can make such application, you have to check whether you meet the criteria for that application. And most people fall into the trap of applying under retention of right for indefinite leave to remain whilst they have not attained the qualifying period. The qualifying period is 5 years. Of course, there are exceptions, especially under bereavement, but the standard qualifying period when it comes to divorce, you still have to have had 5 years. But what we're going to do now is to look at the rule book. So, producer, if you're available, please take us to the rule book, the first one, so that we methodically work our way through the various areas. Right. So, Bragoku, you are going to assist us as well.
Okay.
So
So
it
the new
says,
book here is talking about apply for an EU settlement scheme, family permit to join family in the UK. Uncle.
and it says apply if you have retained the right of residence. So
Yeah.
that's the one we are looking at.
So
Apply.
that's the one that's opened up here. Apply if you have retained the right of a resident. You may
So
be able to apply
so
for an EU.
so let's establish something here. So you
Okay.
see that this one it says apply if you have retained the right. It didn't say apply for retained right.
Hmm.
So I don't expect people to be saying that I'm applying for retained right. I am applying because I have retained my right. So let's not get the two mixed up. Because when the two get mixed up, you forget that you still have qualifying period to meet. So let's work through.
Okay. So you may have retained right of residence, as lawyers is explaining, if your eligible family member died, if their child, if you are their child, they died or left the UK, and you are in education in the UK. Then again, it says you have had a child with them. They died or left the UK, and the child is in education in the UK. The next one says they divorced you or a member of your family. Then finally, it says the relationship is broken down permanently because of domestic violence or abuse.
Good. So the four criteria we looked at for
Mhm,
you to know that you've retained your right. The first one where it says that a family member dies. If a family member dies, in this case, it can be a spouse or a parent or a child. So if you are a parent and you made an application, for example, in the old one, Zambrano, based on your child, primary carer child, and the child dies, you can retain your right because you acquired a right before the child died. And
mhm.
because the child has died, you can still retain because there is death of a family member. So death of a family member who is a wife or husband, death of a family member who is a parent or step parent, death of a family member who is a child as well. All right. Then we move on to number two, which says that you are a child. So here we are talking about children. You are a child. So you are their child, and also you are their child, and the
Mhm.
person dies. So the parent is dead. So if your parent is dead and you are in education in the UK, obviously you have to be considered so that you can continue your education and you've retained your right because your parent who was looking after you, or your step parent who was looking after you, or your grandparent who was looking after you is no more. The third one, you've had a child with them.
Mhm.
They died and left or left the UK. So sometimes the person may not die, but the person might have left the UK. And you are looking, and the child is in education.
Mhm.
You are looking at the child potentially. Then
Yeah.
again, you've retained your right. So you can also retain your right whether the person is in the UK or not, especially where there are children involved. If they have left for their country and they are no longer living in the UK, exercising the right as before, you can rely on the fact that you had a child with them. The child is in full-time education in the UK. You are looking after the child, and so you want to apply because you've retained that right. Or divorce. Divorce is the one that is often the case. I've
Mhm.
divorced my husband, or my husband has divorced me, and so I will have retained my right. I want to apply. With
But look,
with
you know, they divorced you or a member of your family.
or a member of good.
You are involved with the person, but if they divorce a member of the family, what are they trying to say?
For example, so here we are looking at a step. My step parent, my
Okay.
step child. So if Brakoku, you here, um, I have brought you to the UK because I'm married to your daughter.
Hmm.
That makes you my um, parent-in-law, isn't it?
Yes.
So you came in because of my marriage to your daughter,
Hmm.
but relationship with your daughter is broken. Under normal circumstances, I have no more any business with you, isn't it?
Yeah.
But you can say that you have retained your right because divorce is what has brought about that breakdown in relationship between myself and you. And so the divorce of a family member, does that make sense?
Okay.
Yes. So here we're looking at step parent, step children. Um, we're also looking at mothers, or sorry, parents-in-law. Those categories, right?
Okay.
Then relationship has broken down as a result of domestic violence. So these are the four we talked about earlier on. Now the rule. So it says, how do you qualify the eligibility?
Okay.
Eligibility. Yes.
So then it talks about eligibility, eligible family members. So it talked if your family members died, you can apply if you lived continuously in the UK as their family member for at least 1 year immediately before their death. You can also apply if you lived in the UK as their family member immediately before their death. They were living in the UK as a worker or self-employed person at the time of their death. And you can also apply if they have been living in the UK for at least 2 years immediately before their death. So we're talking about you should have lived with a person for at least 2 years.
So you can see, so when it comes to death, there's
Mhm.
bit that people would want to know. Once my family member dies, when can I apply?
Mhm.
So it says that you can apply if you lived with that family member immediately before death. So if I was living with the person and the person died, then as a result of death, I can immediately apply
Yeah.
to retain my right. So
Okay.
here you don't have to wait for 5 years.
No,
You can immediately
it was
apply.
immediately before their death. Yeah.
Yes, you were, but you have to show that you were living with them.
Mhm.
Yes, so you establish the relationship and also establish dependency if is the case, and the fact that there's residence with the person before. So you have to, in addition to the family relationship, you need to prove. You also, and the death you have to prove. You also have to show that there's proof of address for both of you pointing to the same address, isn't it? Because it says
Yes.
immediately before death you lived with them. And they and the next one is that it says that they were living in the UK as a worker or self-employed. That we don't really have a problem, because if the person was exercising treaty rights, either as a worker or self-employed, that is it. And obviously they will be doing that whilst in the UK. So we don't have a problem with point two. Point three, they have been living in the UK for at least 2 years immediately before their death. So 2 years immediately before their death, and the first one says that you have been living with them immediately before their death. So, if the third point is the point where it says that 2 years immediately before their death, what if it is 1 year before their death?
Mhm.
It will not be fair for you to be punished. What if immediately after marriage, I lose my spouse?
Yeah.
We haven't been together for 2 years. What happens? And so there's point one and there's point three.
Three.
If you look at point one and point three, they look alike, don't they?
Yeah, kind of.
The only difference is point three, where it specifically says that at least 2 years. What if there's no 2 years living together? For example, I married my partner abroad later, my partner joined me, and as soon as my partner joined me, death took my partner or the EU person away. I've only lived with a person for 1 year. Can I rely on point one, which says that you lived in the UK as their family member immediately before their death? Yes, I can. Even though not 2 years. So I may not qualify for three, but I can qualify
I can
under one.
qualify under one. Yeah.
So this is how these things work. Then the third one, the last one, which is number four, if they died as a result of accident or what, I mean, those are other stuff. But the key thing is death. Right.
Okay.
So we have established that when there's bereavement, you can apply for either 5 years or indefinite leave to remain immediately. You apply for indefinite leave to remain immediately if you are already on a visa for 5 years pre-settled. You don't have to wait for the 5 years to be up. For death, you can immediately apply. So let's bear that in mind. Let's move on to the next category.
So we move on to the next category, and it says if you are in education in the UK, you can apply if you are in education in the UK and your eligible family member is your parent who has left the UK or died.
Right.
If your eligible family member is your parent's spouse or civil partner who has left the UK or died. You must also be able to show that you were in education in the UK immediately before your eligible family member died or left the UK. You must still be in education in the UK. So if you qualify through any of these circumstances, your parent may also be eligible if they have custody of you, uncle.
So here we are looking at somebody in particular. Who are we referring to? The adult or the child?
The child who
The
is
child.
in education.
Because if you are in education, then you can only be a child, so to speak.
Mhm.
So you are in the UK, your parent brought you to the UK. And while still in education, they left the UK for their EU country. Somebody will say, does it mean the child has been abandoned? Well, if that is what you want to say, you can say, but why will you leave your child if you haven't abandoned them? So if your parent has abandoned you,
Mhm.
then you can rely on the fact that you are in education, so you cannot leave the UK, but you want to remain and continue schooling and apply on that basis, whether death or abandonment. And in this case, the other family member, which is the step, no, not the step, which is the spouse of the other one, for example, can also apply. Because if you look at the third one, it says that parent spouse, isn't it, who has left
Okay.
the UK.
Mhm.
You must also be able to an order. So where the child is there, let's say, so the child is there with the stepfather and with the mother. The stepfather has left the UK for their EU country. The child is in education. So in principle, the mother who depends on the partner is also at risk, and the child is also at risk. The rule is saying that if the person has left the UK or is dead, you, the stepchild, or the child can retain your right, and the other parent can also retain a right,
Yeah, right.
and both of you can apply. Right.
Okay.
So, but the other bit that you have to show as a child is that in addition to all that, you have to show that you are still in education.
Yeah.
So if you're not able to prove that you are still in education, then as a child, you won't qualify
Yeah.
because you wouldn't have retained your right.
Okay.
And again, it says if you qualify through any of these categories, your parent may also be eligible if they have custody of you. So if the other parent has left and you are living with the other parent in the UK, then the other parent you are living in the UK who has custody of you can also
Mhm.
retain their right and apply. So if you are living in the UK independently and the other parent is living elsewhere and the EU person has left the UK, even though you may be able to qualify because you are still in education, the other parent who has no custody of you cannot.
Okay.
So that is the third point
Right.
under the education category. And this is all under children and custody of children. So let's bear in mind. We talked about Dr. BC. Here we are looking at domestic violence. We are talking about relationship breakdown. We are looking at child custody, and we are looking at bereavement.
Okay.
Let's move on to the next one, please.
So if you or a member of your family was previously married or in a civil partnership, you can apply if you no longer have an eligible family member after the marriage or civil partnership ended with a divorce, annulment, or dissolution. You must have lived in the UK when the marriage or civil partnership ended. One of the following must also apply, it says. When the marriage or civil partnership lasted for at least 3 years and the couple had both been living in the UK for at least 1 year during that time, you have custody of your previous family member's child. You must have been given the right of access in the UK to your previous family member's child, and the child is under 18. You must also apply if you or another member of the family have experienced particularly difficult circumstances, for example, as the victim of domestic violence or abuse in the marriage or civil partnership. You can also apply if a member of the family had an eligible marriage or civil partnership and you lived in the UK when it ended. It must be their child or grandchild under 21 years. Um, can we move it up and say that the dependent child or grandchild is over 21 years, or dependent parent or grandparent, Uncle Charles? Last one, your mic is muted. If you could help us with that, please.
Oh, all right. So this is the main one that is frequent or predominant in
Mm-hmm.
retention of right conversations, because a lot of people would have had their marriage broken down,
Mm-hmm.
even though the other partner is still alive. So here, divorce. Most people, apart from 3 years and the 1 year, they will quickly apply for indefinite leave to remain right after divorce.
Mm-hmm.
As we went through, there was no point where it says you can apply immediately.
Yeah, it didn't say anything like that.
But under death, there was something like that. So here, when there's divorce, you don't apply immediately. You still wait for you to gain the 5 years in the marriage. First, you were married, you've been married for 3 years. Some people will marry before coming to the UK to join their family member, and after arrival, 5 years, they apply for indefinite. Some people were already in the UK, they met their lovers, they married under customary law or proxy marriage provisions in their country, which is valid in the UK. They apply for 5 years and they go for the indefinite. If the person was alive, sorry, if the marriage was still valid or had not broken, you wait for 5 years and your partner will sponsor your application for indefinite. In the same way, if the marriage is broken, after meeting the 3 years and living together for 1 year, let's say you live together for 1 year, there was divorce. You were given 5 years, and since you were given 5 years, this is your third year. You don't say that because there is divorce, I'm going to apply for indefinite, even though I haven't been for 5 years. You have to wait. They will refuse your application and tell you that even though there is divorce, there is no continuity of 5 years for you to qualify for indefinite leave to remain. That is the point I want to stress, because a
Okay.
lot of people, as soon as there is divorce, they put in the application. They don't check whether they have done 5 years and they're pre-settled, or they have done 5 years since the marriage was contracted.
Okay.
So if you are living in the UK before the marriage was contracted, then it is 5 years will start from the date of marriage.
Okay.
If you are not living in the UK, but you contracted, obtained the visa, and joined your spouse in the UK, then your 5 years will start from the date you became resident in the UK. These are the things we have to take note of. Otherwise, you put in the application, they will refuse you and say that you don't qualify under paragraph EU 11 for indefinite leave to remain. So we have to give you another 5 years. And if you take it to court, you only waste money and time because court will dismiss on the basis that you don't qualify for indefinite leave to remain. You may have retained your right, but you don't qualify under indefinite leave to remain provisions
Okay.
because there's no exception. The only exception will be death, and this is not a death situation.
All right.
Right. Now, whilst we are here, let's okay, well, let's quickly summarize the rest and come back to the divorce, the timing, what
Okay.
evidence to show. Right.
So then we're looking at the other bit where we're talking about the domestic violence or abuse. And the regulation is saying that you can apply. Well, let me clarify this. Is this a regulation or this is the law?
It's regulation, but it's also a law.
Okay.
Laws
Yeah.
include regulations.
Okay. So you can apply if you are or were their spouse or civil partner in the case of domestic abuse or violence. You can apply if you were or are their partner or civil partner or spouse or civil partner or married partner, child or grandchild under 21 years, dependent child or grandchild over 21 years, and dependent parent or grandparent. Documents you must provide are the ones that we're going to go through now. You must provide proof of your identity, which can either be a valid passport or a valid national identity card. If you're from EU, Switzerland, Norway, Iceland, or Liechtenstein, that is what you need to provide. You may be able to use other proof of your identity and nationality if you cannot provide either of these because of a compelling, practical, or compassionate reason. For example, you cannot travel to get this document because of an illness. When you apply, you will need to explain why you cannot provide a passport or national identity card and provide supporting evidence. You must also provide your family members a valid passport or valid national identity card if they are from the EU, Switzerland, Norway, Iceland, or Liechtenstein. Evidence of your relationship should also be provided. I mean, your relationship to them, for example, a marriage certificate, civil partnership certificate, or birth certificate. Then you also must give evidence that you have been continuously resident in the UK. Those evidences are the ones
Right.
we
No, no. So,
provided. That was for domestic violence. They've talked about bereavement and
yeah.
the child in your custody and education, the rest of the lawyer.
Right. Yeah. So under domestic violence, it tells that you need ID yourself and the other person. So
Mhm.
someone will say, "Well, lawyer, I don't have anything." But why wouldn't you have anything if you have previously been living with the person before the domestic violence issue arose? And especially where you have previously made an application um, under pre-settled status and
Mhm.
been granted. You are still saying you don't have evidence. And you are still saying that you don't have evidence that you lived together at any point in time. It makes it very, very difficult. And so when people make such applications with nothing, they open themselves up. Sometimes the caseworker will check using the person's 3434 application reference from the EUSS application to see whether they've been living in the UK. But what if there's no evidence automatically extracted? Then you have to provide such evidence. So this is for those under domestic violence provisions. And for domestic violence, immediately you can apply for indefinite as soon as you become a victim. But you have to prove residence with them, ID with the ID card yourself, ID identity document yourself and the person, and also the relationship that existed before the domestic violence arose, and the fact that indeed you are a victim of domestic violence. Now let's go to that death. With death, you have to show that there's death. So death certificate. You have to still establish the relationship with them before death. you have to establish that you live with them before death. So a bit of their proof of address, a bit of your proof of address to show residency. Then you can put all together and apply. Someone will ask, lawyer, what if I don't have the death certificate? If you are a family member and you don't have access to the death certificate, then you may not be a proper family member.
Okay.
Yeah. You are the husband and you are telling me you don't have access to the wife's death certificate, then you can't be a proper husband. This has nothing to do with your behavior. How do you say you're a family member yet you don't have access to the death document? Are you not part of the people ensuring that the burial takes place and all that, and still saying that you cannot apply for death
What
certificate?
if it gets into the hands of the Abusiapeni and the Abusiapeni doesn't want to give it to you?
That means Ebusuapen didn't know you after all. All we are saying here is that if you want equity, you must do equity. If you want fairness, you must be fair. And so you can't say that, oh, I've lost my wife or my husband and I want to apply for indefinite leave to remain because the rules say if my partner is dead, I can apply. And yet you don't know where the death certificate is. So
Well,
it's
if you just
important.
joined us, last Vice taking us through the retention of your EU rights and also the things you need to have to qualify to make that application. We're coming your way at the BWF Solicitors, and the program is the community and the law. It comes your way every Saturday afternoon between 4 p.m. and 6 p.m. here in the UK. Your questions, your concerns, we will take. You can send them via text 07399208468, or you can put them in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV. Let me just remind you of our social media handles, and we'll come and continue.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Okay, welcome back. Thank you for sticking around. I've seen that most of you are putting your questions and your comments and even announcing yourselves in the comment section down below, either on Facebook or YouTube. Thank you so very much for joining us. We appreciate that. Share and invite others to join us as well. We're looking at so many shares today, so keep the numbers going up. Lawyer Charles Osman from BWF Solicitors is with us, and we're looking at the topic, um, retention of EU rights. And he's taking us through the bits that will qualify you and what you need for the application. And I believe we will see how to put it in, how long it takes. Somebody will ask, how much does it cost to pay the Home Office application fee? And then your questions. Last one, yes, we're back. We have looked at the Dr. BC, and also looked at some of the documentation we need to gather before we do that. What are the next steps?
So I want us to zoom in on those who are applying for indefinite leave to remain under paragraph EU 11 on the
Mhm.
basis that they have retained their right due to divorce.
Okay,
So this is the scenario.
right.
So the person, for example, who came to see me,
Mhm.
consultation, married this EU national
Okay.
in 2020,
Mhm.
March 2020, obtained 5 years indefinite pre-settled status under EU 14 in 2021.
Okay.
In 2023, divorced, or the marriage broke down, leading to divorce.
Mhm.
In 2024, May, applied for indefinite leave to remain under EU 11, based on the fact that he has retained the right he had, through which he had the 5 years before.
Mhm.
He was refused. We are going to find out whether Home Office was right to refuse him and
Okay.
whether the court was right to dismiss the appeal and whether he has any case at all to pursue anything.
Okay.
Just as we have discussed, the person married 2020, obtained 5 years in 2021, 2023 there was divorce. So the person, let's calculate. We said that if you are going to apply for EU settled status under EU 11, you cannot do it immediately. So you have to show that you have lived in the UK for 5 years before you can apply for indefinite leave to remain under EU 11. This person was married in 2020. We also said that if you marry in the UK, the 5 years starts from the date of marriage. The person married was in the UK, and so from 2020, 5 years count. 2021, 2022, 2023, 2024, 2025. That means 5 years will be March 2025.
Mhm.
He applied in May 2024. Should the visa be granted under indefinite leave to remain EU rules? Yes or no?
Married in 2020.
Yes. Married in 2020. So we count whether he's been in the UK for 5 years because we established that you should count from the date of marriage if you
Mhm.
married in the UK. He
Yeah.
married in the UK and
He married in the UK. Okay.
he had 5 years pre-settled status in 2021. And he applied for settled status, indefinite leave to remain in 2024, May. At the
Mhm.
time he applied for indefinite leave to remain, did he qualify to apply for indefinite leave to remain? because
Was
he
married
should.
in the UK and lived in the UK from 2020. So they passed 5 years in March.
Let's count. So let's count from 2020, 2021,
March
22.
2021, March 2022, March 2023, March 2024, March 2025,
So 5 years will be when?
March 2025.
When did he apply for indefinite leave to remain? May 2024.
Oh, then they had not spent the 5 years yet.
He didn't qualify under EU
They
11.
qualify, yes.
But he heard people saying, bogus lawyers and bogus pocket lawyers,
The car
saying,
boot ones.
saying that, oh, if you have divorced, if you have retention, go and apply for retention, go and apply for retention, go and apply for retention. And he also applied for retention. Strangely, he claims that a lawyer did for him, and I was surprised. But then it is what it is. So when I took him through this, he said that, oh, so I didn't have to waste money and time in 2024. I said, yeah, because you couldn't qualify, even though you had retained your right, you can only apply under the rules for indefinite when you have had 5 years
5 years
residence
continuous
from date
residence.
of marriage, because you
Yeah.
married whilst in the UK.
Oh,
Then he
yes.
said, oh, but the person told me as soon as I divorce, I can apply. I said, not as soon as. As soon as it's only for people who are experiencing bereavement, death, or domestic violence, not divorce only.
Not for divorce alone. Okay.
So now the person is going to apply again. So I said, now you have done 5 years, you can apply again. Now you can apply under EU 11 because you've been in the UK for 5 years since marriage, 2020. But then you have retained your right because you divorced in 2023. But you have to show that one, you married, two, you live with your wife up to the date of divorce.
Mhm.
You see, marriage, divorce. So 2020 up to 2023, the gap must be filled. Because at this time, you were living with your wife, supposedly, as husband and wife. Then separation came from 2023 up to 2025, you are no longer together. So if you are going to prove, you have to prove up to the point you were together, isn't it?
Yeah.
And after that point you were separated, you don't have to prove anything because you cannot have it if you are no longer living with the person. But you cannot say that I have retained my right, but I have no evidence of living with my spouse, even from the beginning. Will it work? Will it work if you have no evidence at all, no residence evidence of living together?
Evidence
Will
is
it
the
work?
name of the game lawyer.
So I told my brother that, look, go and dig out your archives and documents and all that. Find the pieces of evidence to show that at a point in time from 2020, you lived with your madam before
Uh-huh.
madam became fed up with you and left you. He said, oh, I don't have anything. I said, no, you must have something. Because if for nothing at all, you had something before you applied for 5 years.
Obviously, yes.
Yeah, if for nothing at all, you had something. So
Mhm.
you can't say you don't have anything. So go
Yeah.
and look for it. What it simply means is that if you don't have anything to prove that you lived at a point together, you cannot succeed under this rule.
Well, I know people have questions, they have concerns they want to express, people have things they want to bring along, and all the rest of it. So we will give you the permission and opportunity to do that. But remember, we have discussed EU retention of right application, how to avoid refusal. In the comment section down below, keep your comments coming through. All the lines are active now: 0208 493 7345. Send a text to 07399 Earlier on, we saw somebody trying to come through the phone lines. It wasn't active at that time, but now it is. Paula Duku comes in and starts and says that my sister's been asked to resubmit her administrative review. Can you please help with it? Um, Lawyer.
I'm surprised that anybody will be asked to resubmit. What
Mm.
happened to the first submission and what was the outcome?
Ah, well,
And
I don't know.
what is the basis of the administrative review? because you submit administrative review once, so they won't come and tell you that resubmit it. Is it because they didn't receive it? So I need more information to be able to say, it says, please, can you help? Help with what? Help with resubmitting or help with. So, our brother Paul, I think your question would be good for face to face. So please get in touch and let's have a conversation. There's more I need to know.
There's one lawyer needs to know. So, Paul, please, if you could provide further details. Thank you for joining and staying with us on YouTube. God bless you. Let's pick up other ones. I was married to an EU national, and through that, I was able to bring my children through EU pre-settlement. Now we've divorced. What process or how will I renew my children's visas, lawyer?
So once the children have been in the UK for 5 years, the
Mhm.
children will apply on the basis that they are no longer with the mother. I think a stepmother. They are no longer with a stepmother because of divorce. However, before divorce, they were living with a stepmother. So they have to show evidence of living with a stepmother from date of arrival up to the date of separation, divorce. Some people will separate before divorce. And so it's always the point that you were living together up to the point of separation. So the children must provide something for you and for their stepmother and for themselves, living together as a family, and add the divorce certificate. Then apply on the basis that they are applying for indefinite leave to remain, having retained their right as stepchildren of a former EU national.
Well, let's
Another
go to another one.
former
Richard, thank you
stepchildren.
very much. We second lawyer.
And I was saying that having retained their right as former stepchildren of EU national.
Okay. Right. Richard, thank you very much. If you need any further discussion on this one, you can call 0208-493-7340 and speak to Lawyer Asma. Or you can even call him directly on 07947636037. 07947636037. Thank you very much. Let's move to the next one here. And we have something from Jennifer Amwabing. Please, my brother is an overstayer, and his partner is an EU permit holder. Can my brother get married here in the UK without going back home? Laura.
Right. So, in terms of marriage, yes, your brother can, because if your brother, for example, comes from a country where the laws allows for people to marry under traditional marriage rules. In Ghana, Nigeria, and some other countries, there's provision for customary marriage. In this case, your brother can marry on the basis that the partner and himself had their family members represented at the marriage ceremony where it took place, was contracted, then they got it registered. There's statutory declaration from the family members confirming same. There's letter from the judicial service. There's letter from the Ministry of Foreign Affairs, and there's also the marriage certificate, which is the customary marriage certificate. And the advice normally is that you, your brother, between your brother and the wife, the partner, the EU national, must have agreed on paper that they are entering into marriage, which is permanent, of course, for better for worse. Even though that is not part of the standard provisions, you don't want your partner, your brother's partner, to say that I was forced into the marriage. So from the outset, they agreed to have this marriage and started or engage, contract this marriage. Then through they could have then authorized or given permission for family members to represent them, and everything is clear. Now, even though your partner, your brother and the partner can marry under proxy rules or traditional customary marriage rules, the question is, can your brother apply to remain in the UK on the basis that the partner is an EU national? The answer is no, provided there is a child involved. Because we are talking about marriage in 2025. If your brother marries this partner in 2025, that is 5 years after Brexit. And so your brother became a family member of an EU national after Brexit, after 2020. And so EU rules will not apply. What will apply will be standard immigration rules, Appendix FM. Now, he's an overstayer, so he cannot be granted a visa on the basis that he's married to somebody who has residence in the UK. The only thing that will help is where the partner has a child and your brother has become a stepfather to the child. And so, on the basis of the child's best interest, your brother will be allowed to remain in the lives of the partner and the child so that he can be able to play a role in the life of this stepchild. Otherwise, he will be refused.
Well, a word to the wise is enough. Do the right things, keep within the rules, and get it right. And if you have any challenges, contact BWF solicitors and they will help you. Ayinkai, you say no at the time of applying for indefinite leave to remain, he had not stayed in the UK for 5 years. Well, obviously, I think it's to one of the questions earlier. And from the scenario lawyer was giving us, this person whose application we use as a case study had not lived for 5 years in the UK
Since
when they
marriage,
applied
since marriage, since marriage.
since marriage,
Yeah.
since marriage, and um, the person was refused because they didn't really qualify for that threw money away. They just threw money away. Um, Naneti Ahene, um, a child has indefinite in line with her British mother. Mother wants to register the child. The other parent is involved in the child's life, but has 2.5 years leave. Child entered UK 2.5 years ago. Can the child be registered as a British? Um, or both parents must be British before the child can be registered? The next year, he comes up with a very long, double-barreled question, lawyer.
So there are rules surrounding children born abroad.
Mm-hmm.
Children born abroad who are living in the UK and the parent has indefinite leave to remain and so on and so forth. There are rules on that child registration because with that there is discretion of the Secretary of State to grant or not to grant under the relevant rules. For example, Section 3 of the nationality rules, the Nationality Act, and also 1.3 of Nationality Act. So all these rules will come into play before we can make so it's not conclusive whether the child will be granted or not. But Nana, if this is a living case, then please let's have a wider conversation around it so that we can help this child.
BWF Solicitors, fourth floor, Vienna House, 214 to 218, Tottenham High Road, Seven Sisters North, London, 0208 493 7340. Those of you in Ghana, you can call them on 055 589 5959. Or in emergency situations, send a text, WhatsApp, or call 077127 61884. Yes, the lines are active. You can call in now on 0208 493 7345. Ainkai comes up with this one. I have a brother who's on a dependent visa where the main applicant sponsor's license has been suspended. Can my brother either get married to a British citizen or get married to another person on a skilled worker visa working in the NHS?
So the brother is dependent on a skilled worker migrant, I suppose.
Mm.
Okay. So if you have leave to remain in the UK, which is exempt or valid, you can switch to another category.
Mm-hmm.
This person has visa which is valid as a dependent of a skilled worker.
Mm-hmm.
This person can switch to another category, i.e., as a parent or as a partner of a British citizen or somebody who has settled or somebody who is even also a skilled worker.
Mhm.
The thing is this, that you cannot move to another category as a spouse without first divorcing the the dependent or the person that you are married to. So this person must first be to prove that the marriage is dissolved. Then again, prove that there is a new relationship formed, and this is the marriage evidence. Then the person will apply. The question is, at the time the marriage is dissolved and there is evidence of divorce certificate, will the person's visa still be valid? This is the rule. Once the person's relationship is broken, the main applicant, the sponsored migrant, must tell the government that my relationship with this person is broken. This person will be sent notice with 60 days telling him that there is evidence that, or note, information that the relationship is broken, and so he cannot remain in the UK because the relationship is no longer subsisting. Once you are given 60 days, your deadline for the visa to expire is now shortened to the date up to the 60 days. And so within that time, you can rearrange and switch to another category. So far as you're able to switch to another category before the 60 days is up, is fine. The rest will be legal argument whether the relationship is genuine and you met the rules.
Well, the two quick ones probably before we come to the point where we'll go for our quiz. One is from the person sent the letter that the Home Office has written to them, but for time and inability to redact the names, I will just summarize this. The person had sent an application to the Home Office and it's been with them for almost 24 months. The person's visa uh, was about to expire, and they made an application before the expiration of the existing one. But the previous one they sent to the Home Office is still sitting with them. The passport is still sitting with them and everything. The person has written to them several times. Just recently, he sent another email, and they have come back to say that once they have done an in time application and the passport is sitting with them, they don't have to have any concern because Section 3C covers them, and that they shouldn't even contact them and wait until they make a decision. What should this person do, lawyer?
So this person, if I can summarize the issue, he has application pending, right?
Yes.
And Home Office has written to them to say that don't worry until a decision is made. Wait, is that the point?
Yes, and that
So
their right to rent, right to bank, and all the other things
yeah,
are still valid until a decision is made.
and that's what Home Office is telling them.
Yes.
And so, what is their worry?
Well, they say, what should they do? What should they respond to the letter?
Oh, this letter is not demanding anything; it's informing you.
Okay.
It's just telling you that, my brother, be patient. The Lord is with you.
But well, almost 2 years.
Yeah, but they've given reasons why he shouldn't worry.
Okay.
Unless he's saying that I have to travel because my mom, my dad, somebody is seriously ill, I have to be there. Otherwise, then you ask for what we call expedition of decision so that they can expedite the process. But you have to then provide evidence that you need it to be able to travel to attend to a bereaved family member, to attend to the funeral of a family member,
Mm.
or attend to the ill health of a family member. And the family member here is either your parent or your child, not other family members.
Okay. Well, let's go to the phone lines. I've had this person hold on for quite some time, and I appreciate that. I want to apologize. Hello.
Hello. Yes. Good afternoon.
Good afternoon,
Good evening,
boss. Sorry
rather.
for keeping you holding.
It's okay. It's okay. Please. The question is, I am an overstayer,
Hmm.
and then my partner is on a dependent skilled worker visa.
Yeah.
Right now, she's pregnant,
Okay.
and I want to know if she gives birth, will I be able to, based on the child, to apply for, let's say, a 2.5 visa?
When did your relationship start?
It started last year.
Last year.
Yes, please.
Okay. And at the time that you went into that relationship, you were an overstayer. Okay. Is
Yes,
that
I
correct?
was. Yes.
Okay. Let me hand you over to Leah. Leah,
Right. Hello, bossman. How are you?
I'm doing fine, sir.
Good. So, as we speak, you don't have a visa. Your wife has skilled worker visa. Once you have a child, at best, your child will be given skilled worker visa as well. But the worst case scenario is that your child will be refused a visa. Do you know why? Because your child will be applying and saying that my mother has skilled worker visa, but my father is an overstayer. And they will say that because your father is an overstayer, you cannot be granted. So there's risk for your child. Now, even if your child succeeds, you cannot succeed because you are an overstayer, and your child will not be a qualifying child because your child only holds limited leave to remain under skilled worker provisions. So the only time you can be saved is where your child is a British child or your child has indefinite leave to remain.
Okay. Okay.
now, can I extend this question this way? Now, this is somebody who has overstayed. The partner has limited leave to remain. Possibly, the partner came in all by themselves. Can this gentleman go to Ghana, get married, and the partner applies for a spousal or a dependent visa on their status and bring him back here?
That is an option provided this gentleman has the level of risk appetite required to take such risk.
Risk appetite. I love that. And that's one of the um, concepts in management, I guess.
So what it means is that if I sit here and tell you that, oh, if you're applying from abroad and your wife was a skilled worker before the rules changed on the 11th of March 2024, of course your wife can bring dependent. But if you go, will you be able to get a visa? When you are applying, normally they will ask you, have you ever overstayed in the UK, right? And you have overstayed. So you say yes. Will that affect the decision? I can't tell. And that is where it depends on your risk appetite.
Mm. Okay. Amazing. Thank you very much.
Well, thank you as well. Thank you for your call. If you would really want to have any further thing on that, you can text or call 0771276188 or call Charles Asma directly 07947 636037. Well, we almost run out of time. When the exciting things are going on, we tend to forget we have other things to do. But let's go back to quickly look at our quiz and then also see if we can have your answers quickly before we draw the curtains down. Isi Kwansima works as a domiciliary carer with the Abacus Care Agency. A, a typical day, she travels for 4 hours to get clients to provide care. She works for 60 hours a week, including travel time of 20 hours. She was concerned that although she works 60 hours a week, she's only paid for 40 hours. She wants to take her case to the Employment Tribunal for an unlawful deduction of wages. Is she likely to succeed? Three options. No, because travel time is unpaid, as it does not involve working. Yes, because she travels to the client's homes, which involves paid time. And no, because her contract of employment is for 40 hours a week. What are your answers? Get them ready and let's see what you have. Alfred Chimesi says no, because travel time is unpaid, as it does not involve working. We next have Grace Broby thinks that no, because her contract of employment is for 40 hours a week. Justice Watson thinks it's number three, no, because her contract of employment is for 40 hours a week. And as Kakari comes in to say no, because travel time is unpaid, as it does not involve working. Stella also thinks as well that it says number one, no. Lydia Paul says no, because travel time is unpaid, as it does not involve working. Kwesi Apia thinks it's number three, no, she can't succeed. Then the reason is because the contract of employment is for 40 hours only. Precious Owusu says yes, she will succeed because she travels to the client's homes, which involves paid time. Okay, the next one we have here, Ishmael Opoku thinks yes because she travels to the client's homes, which involves paid time. We have Emmanuel Osei being the last one, yes because, no, sorry, Emmanuel, I was going to give you a different answer. No, because travel time is unpaid as it does not involve working. Citizen Joe drops in and sneaks in and says, number one, no, because travel time is unpaid as it does not involve working. Last one, two, or three. Which one?
Right. So we had a case of HMRC, and if we go back to the nugget so that we understand the context. So the case of
Sure.
HMRC and Taylor Services Limited and others, and this is a 2025 citation, Court of Appeal. The court concluded that if you are paid, that money should be enough for everything, including your travel. So you cannot be paid differently. And so the answer is no. Number one.
Number one. Okay, so my dear lady, you won't succeed because actual work while traveling is yes, but this one there that you go in there and you work. But within the working hours, that's not what you're doing. You're not traveling. Travel is considered time worked only if it is for the purposes of work and occurs at a time when the worker would otherwise be working. Talking about the case that was quoted, and lawyer has made reference to that. To those of you who said two and three, unfortunately, you didn't get it correct. It's number one. Yeah, we've had a very nice discussion today, full of steps, consideration, criteria, and all that. Retention of right. What did we talk about? Can you help us summarize?
Sure, I can. We looked at EU retention of rights, how to avoid refusal. One thing that creates refusal for or causes refusal for people is that they will be relying to apply for indefinite leave to remain based on divorce. Yet they will not look at whether they have spent 5 years in the UK from the date they arrived or from the date they married, if they married in the UK. So the 5 years is standard before you apply for indefinite leave to remain. Because retention of right application is not a separate application. It's just a factor giving you a springboard to jump to the next stage, even though you are no longer with that family member. And so, even though you are no longer with a family member, it doesn't take away the fact that you have to meet the criteria. So, in applying, once the family member is alive, you must show 5 years of living in the UK from date of marriage. If the family member is dead, then you can apply for indefinite immediately. If you are going through domestic violence, you can also apply for indefinite leave to remain immediately. However, in all this, check whether you meet the requirement under 5 years or indefinite leave to remain, EU 14 or EU 11. If you don't, your application is likely to be refused. This is what we covered.
And that draws the curtain down for us. We don't have to bring it down, but it draws it down for us. Charles Asma, thank you so very much for your time. Thank you for your depth of knowledge. And thank you for your patience and all the skill in doing the presentation. We've learned a lot, and we would want to believe that if there's any further concern or question, we can have the chance to visit yourselves to have that. BWF solicitors 0208 493 7340. Fourth floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters, North London. Come join us again, same time next week. But together, let's say thank you to Lawyer Charles Asma for his time and effort. And also remember, we are in the pink month. We're looking at breast cancer awareness. So, in this month of October, please let's stay safe. Let's advise our people. If you have any experience to share, you can send us a very short video. We'll play and get people educated. You can send that to us via our text and WhatsApp number 07399208468, 07399208468, or you can drop them in the comment section on our social media handles at BWF Solicitors. And we shared that, like we did share the one earlier on from our very own doctor. So, on behalf of the family at BWF Solicitors, from the senior partner to the very last person, that's me, and also on behalf of my production team made up of Fatma Dodu, Sheila Ankra, and my indefatigable producer, Professor Ade, want to say thank you very much for sticking around with us. We would have the opportunity to come your way again same time next week. So as that, we inviting you to join us. Please come and let's do it together again same time next Saturday. Until then, be good.